A pleasant day, everyone. Greetings. I am Paul Edison Silva from BSA 22, and today I will present to you the case GR number L25897 last August 21, 1976, with Agustin Dormitorio and Yosha D. Dormitorio as the petitioners, and the Honorable Jose Fernandez, Judge of the Court of First Instance of Negros Occidental, Branch Bacolod City, and Serafin Lazalita as the respondents. This case presents how the petitioners will perform animus novandi and the execution of ex parte motion as they won the petition. And now, moving on to the facts, starting from the petitioners or plaintiff's claims, it was determined that the spouses Agustin and Leoncia Dormitorio purchased a lot from the municipality of Victorias, specifically Lot 2, Block 16, in a lump sum using cash basis as their payment. However, the current respondent, Serafin Lazalita, resides within the lot spouses Dormitorio bought even before the land was even bought by the spouses. So after filing a petition, it was found out that the lot where Lazalita occupies and bought through installment was truly owned by the Dormitorios, in which the Honorable Jose F. Fernandez rendered a decision in favor of Dormitorios. After the decision of the writ of execution, the spouses believed that the grave abuse of discretion was performed by the respondent judge and that they were not informed by the respondent judge of the petition. So now for the respondents or defendants' claims. On December 7, 1948, Serafin Lazalita purchased a lot from the municipality of Victorias, specifically lot number 1, block 16 of the Consolidated Subdivision Plan, thesis 118, having an area of 230 square meters, payable in installment at 1 peso per square meter. In the petition filed by the spouses Dormitorio, Lazalita failed to appeal from the said judgment in civil case number 5111 of the Honorable Court, so the respondent brought an action against the municipality of the Victorias and has also coordinated with the Dormitorios as formal parties due to the value of his permanent improvements and building on lot number 2, block 16, in which it exceeded the original purchase price of the land. While for the respondent judge, he granted the relief prayer and set aside the writ of execution he previously issued, and with them, in view of the conclusion reached by him that such later decision arrived at the result of a compromise between the same parties, evidenced with the agreed stipulation of facts that the erroneous issuance of the writ of execution was due to the ex parte motion and was a clear proof of animus novandi. So lastly, for the facts and decisions of the lower courts. The Court of First Instance of Negros Occidental, Branch 5, headed over by the Honorable Jose F. Fernandez, rendered judgment in that case number 5111 in favor of the Dormitorio, ordering the plaintiff herein Lazalita to vacate the land and to pay a monthly rental of 20 pesos to said Dormitorio, beside his attorney's fees. So after learning that he was misled by the former plaintiff, the spouses Dormitorio, Honorable Jose F. Fernandez granted the relief prayed for and set aside the writ of execution in view of the conclusion reached by him that such later decision arrived at the result of a compromise between the same parties, evidenced by the agreed stipulation of facts, was a clear proof of an animus novandi and thus superseded the previous judgment which as a result of an ex parte motion was mistakenly ordered executed. So moving on for the issues. The issue present in this case is whether or not the previous judgment of the Honorable Judge, which as a result of an ex parte motion, was mistakenly ordered executed. And now for the held. First, the disposition of the case. The court has decided that the petition for the certiorari is dismissed with costs against the petitioners. And now last, for the held part, the dictum. The court used different cases, such as the case of Santos versus Acuna, to further determine the accurate judgment for this case. In Santos v. Acuna, the decision of the lower courts were innovated by the subsequent agreement of both parties, but in this case, there is no subsequent arrangement entered into with any unqualified intention to replace the previous judgment. Without any intent or animus novandi, there will be no obligations that could take place. Additionally, the court believed that the later decision in civil case number 6553 had the effect of res judicata, in which the parties are bound by it. Still, the petitioners performed an element of bad faith by evading its terms. Also, the petitioners have claimed that they were not informed by the respondent judge of the petition by private respondent to set aside the date of execution. But the court believes that they were given the opportunity to file a motion for reconsideration and procedural due process in which the petitioners cannot deny. So that's all. Thank you for listening, everyone. Have a nice day. Stay safe.